Hi everyone, Sharifa here at ST Law Office. I am U.S. Immigration Attorney and I run ST Law Office. I am here to answer your immigration questions. So if you have an immigration related question, please go ahead and drop your questions and I will go ahead and answer them. I usually come with a particular topic, and today I am going to talk about the process of applying for the green card in the United States and applying on your own, and ways that you could do that. So, the ways that you could apply on your own. That's what I'll be talking about, but you are my priority. Your questions are my priority. So, please go ahead and put your questions in the comments. Hi, Kay Johnson. It's nice to see you. So I'm going to be talking about applying for the green card as on your own. However, once the questions come in, I will stop talking about the topic to answer your immigration questions. So I am usually on here for half an hour, so time is ticking. So please go ahead and put your questions in the comments. Now, self-petitioning, what is that? So there are ways to apply for the green card on your own. So the way I'm going to talk about is through family immigration. There's also a way to petition for yourself if you it's more employment based, and it's if you are at the top of your professional field in science, arts, athletics, business. So in those areas, if you have reached the top of your field and you have sufficient documentary evidence, usually you have to show 3 out of 10 specific type of evidence, then you could apply for the green card under what's called the Extraordinary Ability Green Card. And that would allow you to apply without an employer, without having to go through any kind of extra certification processes like the labor certification process. But there is another way, and that is through family based immigration. You can self petition if certain family members are refusing to file for you, and that amounts to mistreatment. So they may be, if your family member is refusing to file for you because there's the underlying motivation that they want to keep you under control. They want to keep you from gaining your status to be able to have leverage over you, then that could qualify for this type of it's called self-petition process, where you can apply for the green card on your own. So I just want to stop for a minute to let you know that you are welcome to put your questions in the comments. Your questions don't have to be related to what I'm talking about. You can ask anything you want that's immigration related. For those of you who don't know me, I am U.S. Immigration Attorney Sharifa Tharp. I'm based in Florida, but I represent clients all over the country and the world. Because as an immigration attorney, we are able to do that. So if you want to check out more about me, my practice, the law firm, what I have done for other clients, you can go ahead and check out the link in my bio. That's going to take you to the website. And while you're there, you can give my office a call. The number's on the website as well. The number is 561-405-4889. And what usually happens is you will speak to the firm's receptionist that will get you on my schedule for a consultation. So there it is. So let's go back to my topic until I start to see questions come in. Hi, Slick White Line. It's nice to see you here again. So self-petition, the self-petition process, right? If you are experiencing mistreatment by a U.S. citizen or legal permanent resident spouse, parent, or a son or daughter who's a U.S. citizen and 21 and up, then you could apply for the green card without anybody else. You don't have to have a sponsor. You could just sign your own application as the applicant and then include evidence to show that your spouse, your parent, or even your son or daughter who's 21 or up are mistreating you. So what counts as mistreatment? There's the misconception that mistreatment is abuse, that it is physical harm, it's physical violence, and that is not the case. If your relative is simply refusing to file for you as a control tactic, because they know that if they keep you in a temporary status or they keep you undocumented, that they can continue to have leverage over you, that can qualify for VAWA. So if your relative, the qualifying relative, which means the U.S. citizen or legal permanent resident spouse, parent, or son or daughter, citizen son or daughter 21 and up, if they're verbally abusive, if they're emotionally abusive, that's name calling. If they're controlling, if they're financially abusive, that does count as well, qualify. So what kind of evidence do you show this, right? Because you don't exactly call the police because someone is being verbally abusive. So how do you prove that this is occurring? And there is a specific art to. You definitely would have to present the evidence in the right way. K. Johnson, 28. If you have an aggravated felony and were deported, can you re-enter the U.S.? So unfortunately, there is no waiver for an aggravated felony, but there is that other. Now, if you are coming back to the United States on a temporary status, there is a waiver. It's like asking for forgiveness to come in temporarily. But unfortunately, the aggravated felony means that there is a permanent bar from obtaining permanent residence and citizenship in the United States. And there is no waiver available for this. But if you say you have your family here, your mother or your children are here, and you would like to visit them, there is it's called a Haranka waiver. So it's submitted on on a specific form, and it basically you are asking for forgiveness to enter the U.S. temporarily, but unfortunately you wouldn't be able to get a permanent grant, so you wouldn't be able to get a green card. But mainly the main thing they want to see with this waiver, although approval is never guaranteed and it's up to the officer. So how you usually apply for it is when you're applying for your visa, you'd also go with your waiver in hand, your prepared waiver, and that waiver usually shows the purpose of your visit, how long, the fact that you've been rehabilitated and that it's unlikely that you will reoffend or recommit any kind of the violations. And if the officer sees fit, they will recommend it for approval, and then it goes to an office for a decision. And then once you get a decision, and if it's approved, which is never guaranteed, but if it's approved, then you could make the trip temporarily. But with an aggravated felony, that is the only other option, unfortunately. Great question. If you have more questions, please go ahead and drop them in the comments. I'm talking about applying for the green card on your own. So if you have a U.S. citizen or legal permanent resident, spouse, parent, son or daughter who's 21 and up and a U.S. citizen, they are mistreating you, they are refusing to file the green card, and even if they file the green card papers but they're still mistreating you and you can't take it anymore, you can go and change over from the process where they're applying for you to the process where you apply for yourself. So what kind of evidence can you show? So there is an art to this, but you can include a detailed statement. It's called a declaration, and that is what I work with my clients to put together. So there's a declaration. If you have police reports, restraining orders, that's fine. If you have if you don't have that, then there is also the expert report. So if you've had meetings with psychologists, or in any case, we could arrange for you to have meetings with a psychologist who can write up a report and talk about the impact of the mistreatment on you. So even though you may be lacking evidence, because it's hard to prove, to come up with evidence for verbal abuse. Also text messages. So if you have text messages, make sure you save those. Video, anything like that, then save that as well. Those are examples of the kind of evidence you can use, but you could also get creative with it, because they require credible evidence, and which means believable evidence. So as long as it's believable. If you have immigration questions, please by all means go ahead and drop them in the comments. I am here to answer your immigration questions. So I usually come with a topic to talk about in the meantime, while the questions are coming in. So go ahead, drop those questions in. So the topic I'm talking about is applying for yourself, especially in regards to the family immigration process. So in the case of a family situation and you are being mistreated by a U.S. citizen, legal permanent resident, spouse, parent, or a citizen, son or daughter who's 21 and up, you can apply on your own. Now, another thing is, well, what if the trouble with your U.S. citizen, son or daughter 21 and up, started when they were 18 or started when they were under 18? Does that still qualify? When they turn 21, you could still talk about, go back in time and refer to what happened even before they turned 18. So, or before they turned 21. So it still would count. Hi, Godchild051. It's nice to see you. So another thing is, if you were a child, so if you are a minor under 18 at the time that there was abuse and you really didn't know where to go or what to do, you're over 18 now, you can still qualify for this relief if your parent, your U.S. citizen or legal permanent resident parent mistreated you or refused to file the paperwork for you. And you could qualify up to, as long as you don't reach 25. So right before the age, you have up until you turn 25 to file for this type of application. So even though you may not be a child anymore, you could still apply for that green card. So keep that in mind. So how does the process work? So once we figure you qualify, that we put the evidence together, we prepare everything. The next step is to move to apply, to submit the application to the relevant location and with the evidence, and then comes the biometric, the fingerprinting appointment. Then after that, if you apply for a work permit, you would get your work permit about 6 to 8 months later. And then you would have, hopefully you wouldn't get an adjustment request for evidence. Sometimes that does come, and it's just make sure that, as the attorney on the file, I make sure that I respond to the request for evidence sufficiently and on time. That's super important. Then after the request for evidence and they get everything to their satisfaction, they'll make a decision on that application, and once it's approved, it then moves on to what's called the adjustment of status process, and that's basically the applying for the green card in the U.S. So now you've reached the point where they're going to schedule an interview for you, and you're going to attend the interview, where the officer now is going to ask you questions about whether you are eligible. They're going to ask questions about your background, if you have any past immigration violations, if you have any past criminal issues. And if they find that on top of the approval for this application that you qualify in other ways, then you would be approved for the green card and get that 10-year green card. So Godchild 051, how long does it take a sibling to get a green card when they're citizen? So this is a very popular question, and I'm glad you asked. It's taking, so for the Caribbean, it's taking about 14 years right now. It's very long, impossibly long. Mexico is taking 22 years. I believe in the Philippines it's taking about 19 years, and in India it's taking about 15 years. Everywhere else is 14 years. So you have to be very invested in this process, and it's definitely not a quick solution for a sibling that needs to get to the United States, unfortunately. But that is how long it is. We don't know what the Biden administration may bring. I don't know if that is, they want to improve the length of time that it takes for family members to come together. They haven't really said anything about siblings, applying for siblings, but the hope is that they would be included in this as well, because that's just impossibly long. So much can happen in that time. And great question again, if the sibling is living in the US, then it would not be the best way, because it's still taking 14 years. So it's not a quick solution or a quick relief for for a sibling that may be undocumented in the US. And then they will need a waiver. Because if your sibling is unable to maintain legal status and they're here undocumented, then they accrue what's called unlawful presence, and that's basically an immigration violation. So if you stay without legal status in the United States for 6 months or more, then if you leave the country, that's an automatic 3-year bar. You can't come back to the United States for 3 years. Unless you apply for a waiver, of course. That's for forgiveness, but that's a whole process in itself. If you are in the country for 1 year or more and leave the United States, that's a 10-year bar. So definitely, if a sibling is in the United States and they have been living without status for that long, they will definitely need what's called an unlawful presence waiver. And they will need to have a U.S. citizen or legal permanent resident, spouse or parent, to have extreme hardships without them to be able to apply for this waiver. So in order to qualify for the waiver, your sibling then would have to apply for the waiver based on their legal permanent resident or U.S. citizen, spouse or parents' extreme hardship. Even though you as a sibling, if you were sponsoring them, it would still have to be based on their parent or U.S. citizen spouse hardship. So as you can see, it will definitely get a little more complicated. Definitely seek legal advice before submitting any applications to make sure you're prepared for what is to come. So great question. The best approach to the sibling, applying for a sibling is if your sibling is outside of the United States. Of course, if they're already living in the United States, you couldn't tell them to leave, because if they leave, then they couldn't come back. So that puts them in a little bit of a pickle. Great question. Please go ahead and drop your questions in the comments. I'm here to answer your questions, and I am finishing up on my topic of how you can apply for the green card on your own if a U.S. citizen or legal permanent resident spouse, a parent, or a citizen son or daughter who's 21 or up, if they're refusing to file for you and there's mistreatment at the same time. So once you attend that interview, the adjustment of status interview, then all being well, that is where you would know whether you are approved for the green card or whether you need to provide documentation, or whether you're denied. So great. So I don't see any more questions tonight, and I have finished the topic that I was talking about, which is how to apply for the green card on your own. I come on here daily, so if I missed your question for some reason, if I didn't see it, then please go ahead and hold on to your question, and I will I will come back on tomorrow. As you'll get notice, follow me, you'll get notification that I am live, and you could come back and ask your question. Thank you, Godchild051, for your question, and thank you, Kay Johnson, for your question as well. And I will be back. So hang tight, hold on to your question, and we will talk tomorrow. All right, have a good night, guys. Bye.